Ladies and gentlemen, with reference to the clock that's in front of me, it does now appear to be 2 p.m, so I believe we should resume. Now, can I just check? I believe we probably do have one person in the room who has not been here before. So I will formally introduce myself. My name is Ryn Smith. I'm the inspector appointed to examine the Allocations local plan. And the programme officer for the examination, Lynette Duncan, who I guess you've already spoken to in the break, is here as well and able to deal with any of the procedural matters and document-related matters emerging from the hearings. I think we will do a round-table introduction, given that you haven't met others who are here. I'll just briefly highlight that this is the final hearing session of the first group of hearings that were largely set out to deal with higher levels strategic issues and the relationship between the allocations plan and the adopted core strategy that provides its context and national policy and practice guidance. In December, we're going to move on and deal with the specifics of individual policies. There will be new agendas and a revised programme issued approximately 1 week before the December hearings commence. Toilets, if they're needed. Ladies' toilets are to my right in the lobby, and gents' toilets exit the lobby, turn left into the committee room corridor, halfway down the corridor on the left. There is no planned fire drill, so if it happens, it's the real thing. Exits are easy, straight down the big staircase and outside. You will note that there are microphones for everybody. These sessions are being recorded, and we're at least trying to make sure that we have a record that's of sufficient quality to go onto the web after the conclusion of these hearings. Okay, now just checking that everybody who needs sight of them has sight of the current programme and the agendas that were issued on the 29th of October. Yes? Okay. I'm not proposing to take an afternoon break today, as this is a shorter session, and we need to conclude by 4 p.m. because we have to vacate this room. Of course, if we finish early, we'll finish and leave once the business is concluded. If I can then ask the council to introduce themselves, and then I'll move to this side of the room, and others can introduce themselves. So, for the council.
Thank you, sir. My name is Kelvin Hinton, and I'm the Planning Policy Manager with the council.
Yes, good afternoon. I'm Adrian Toffs, and I'm Planning Policy Team Leader with Tunbridge Wells Borough Council.
Thank you very much. If we can move to the CPRE.
Good afternoon, sir. I'm Mark Booker, a member of the District Committee of CPRE.
Thank you very much, Mr. Booker.
Elizabeth Aikenhead, Chairman of the District Committee of CPRE for Tunbridge Wells.
Thank you very much, Lady Aikenhead. And now for Cooper Estates.
Hello, so it's Robin Buchanan, Provision Planning Consultants for Cooper Estates.
Thank you.
Thank you, sir. It's Mrs. Annabel Graham-Paul of Council, representing today Cooper Estates, instructed by Mr. Buchanan, standing in for Mr. Jones, who is reforming the planning system in Ireland at the moment. So he sends his apologies for not being here today.
Sounds a considerably more compelling task than maybe the one that he's avoided. But anyway, interesting. Now, the programme officer is circulating an attendance list, so if I could ask that anybody who hasn't signed in already does so before they leave the building. In terms of preliminary and procedural matters, there is nothing on my list because this session is here to deal with the wrap-ups of all of the issues that arose in the preceding sessions. So we can move directly, unless anybody has any matter that they want to draw to my attention relating to procedure, to the remaining matters in Matter J that we'll be dealing with today. And those are two. The first is to hear from Cooper Estate Strategic Land and the Council in respect of the progress made on the late C2 figures that were submitted on Monday, and where sensibly everybody asked for some time to think about them, and I also asked that there be a meeting between the Council and Cooper Estates to try and resolve the largest possible agreement on these figures. Now, I'm open to suggestions on both sides as to who might lead out on this, but
I have just had a brief discussion with Mr Hinton just before we resume this afternoon. So, if I may just say what I said to him, which is, as you're aware, you asked for some agreement between the parties to seek to narrow the issues. We received the document that I believe was handed to you at the end of this morning's session at 4:30 yesterday afternoon from the Council. That has not given us very much time to either consider it fully or understand the methodology and the figures, or indeed to any opportunity to discuss it with the Council. So it is not an agreed document. Right. It is a Council document. What I've suggested to Mr Hinton would be helpful is if we are able, because we do have some questions about it from the Council, it may be easiest if we use the opportunity now simply to go outside the inquiry with the Council officers and ask those questions so we understand what the Council's methodology is in it. The options thereafter, depending on, assuming we can understand what it is either, if you wish, we can go away and prepare a written note, or we can seek to come back this afternoon and state what is agreed and what issues that remain in dispute. But it may be that we need to play that by ear a little bit, because we need to have that time with the Council to fully understand what's been done.
Okay.
I understand Mr Hinton is agreeable to that.
Right.
Course.
Mr Hinton, let's hear the Council's perspective on this.
Thank you, sir. We are agreeable to that. As I understand it, the outstanding questions or queries might be relatively straightforward and easily addressed. And on that positive outcome, that would enable us to come back and address you on all outstanding matters. But obviously, until we have the discussion, I can't be absolutely sure of that. But my understanding is that 15 minutes may well achieve agreement on the figures.
Okay. Well, look, on that basis, subject to this being good and efficient use of time, because what I would actually like to do is to continue to sit, if at all possible, Mr Hinton, and if maybe Mr Tofts or somebody else from your team could remain with me, we can review the general list of essentially homework matters that have arisen from the rest of the hearings and that don't bear on this, and we can progress that and finish it. And by the time we've finished it, I think we'll probably need about 20 minutes, maybe half an hour at maximum to do that. By the time we finished it, if yourself and Cooper Estates were then in a position to come and put a more concluded position in front of me, then that would be an excellent use of time. However, if we need to break and start kind of sitting out in the quiet room for the remainder of the afternoon whilst conversations happen, I think my preference would probably be to reluctantly reserve this for a written process, subject it to the same deadline as the general 5-year housing land supply figures agreement paper, and take it that way. So, if you're able to give me at least one member of your team to conclude the homework issues, I think we have a prospect that's worth following.
That's fine. So Mr Tofts can help you with the homework matters while we're discussing the outstanding issues with Cooper Estates. That's fine. Okay. And to keep us on track, if we can target ourselves for no later than 3 p.m, please, to come back to address me on those points. And whilst you're speaking about your agreement,
when this is presented back to me, me being a bear of relatively little brain, I would be very grateful for somebody to set out a clear, agreed definition of the terms site, unit and bed for the purposes of this analysis, so that we're absolutely clear that when I'm looking at numbers, I know to which those numbers refer. Yeah?
That's fine, sir. Yeah.
Excellent. Right. In which case, that matter will come back as soon as it can, but no later than 3. Those that need to leave the room, please feel free to do so. Now then, ladies and gentlemen, this next matter, as I see it, is essentially just a matter between myself and the Council. And CPRE are, as I've indicated, more than welcome to spectate, but unless you feel it necessary, I don't think this is a matter on which you would speak. Now, I've been reviewing my notes over the lunch break just to make sure that I've captured a reasonably up-to-date list of the various items of homework that seem to have emerged in the last few days. And I'm just going to run through these in an order no more logical than it is the time in which they arose. The first item was that there was to be a process to deliver the best possible agreement between Cooper Estates and the Council on the C2 figures, which I was hoping would have been discharged by now. It's still outstanding until 3 o'clock. And if it can't be dealt with by then, it will remain outstanding. My view, as I've already articulated, is that if it remains outstanding, reluctantly I would accept a submission to the same timing as item number 2, which is, again, the conclusion of as close to a statement of agreement as can be achieved between the Council and the remaining housing stakeholders on 5-year housing land supply figures by the 24th of November. Now, that was 2 days before the date on which documents are due, and the reasoning for that is so that there's time for an agreement to be reached and documented, and then my view is that that comes into the public domain on the 24th of November, and then folk who are maybe wanting to put finishing touches to other documents do at least have sight of that in advance. Is that still achievable?
Yes, certainly. So we will try our best to get an agreed statement. I obviously can't say now how much agreement will be in the statement.
Indeed not. But I think the important thing that I just wanted to make sure is that we're still of a common mind on the date. So if we just step back to item number 1, which is Cooper Estates, that's what I'll be asking for from them and yourselves if they can't reach an agreement in their small room with towels wrapped around their heads this afternoon. Now, in terms, Mr Tofts, of you taking detailed notes on this, what I'm also proposing to do is to issue, through Mrs Duncan, my own list. So you can probably be fairly relaxed about the notes that you take, unless you think I've got something terribly wrong. Number 3. There was going to be a discussion with the Access Group to secure a position statement on any particular changes that are sought to the plan. And this was a process that would involve a conversation between the Access Group and the Council about the function of the plan as largely an allocation rather than a strategic document. I mean, essentially what I don't want is a raft of material from the Access Group that can't realistically be responded to in an allocations plan. If there are residual balance issues that can sensibly be responded to, it would be useful to know. And again, there by the general document deadline, by the 26th. Item number 4, Mr Songhurst, in respect of Folhurst Wood, has submitted evidence in respect of cat predation. That material I've indicated to the programme officer I will accept into the library so it can be published forthwith, and all I'm asking for there is that the Council and relevant parties, and this is especially Berkeley Strategic, can respond to this in their written statements that they prepare in any case for Matter F. And so the deadline for that is the 26th of November. The 5th matter was that the Council are to provide indicative development yield figures for the Civic Centre allocation site, RTW2A, and that's been discharged. We have those. But item number 6 that flowed on from that was that the Council are going to seek further instructions on members' stroke the leaders' position in relation to the emerging position on the location of a university campus development in the borough and its relevance, if any, to ALRTW2A. By the 26th of November.
Just on that one, sir, Kelvin has spoken to the leader and he will be able to give a verbal update today, I think. So.
Oh, thank you.
Unless you particularly wanted something in writing.
I'm very happy to have it in orally today, and then it's discharged. There's no need for it to be in writing if it can be dealt with now. I'll just star that one so we come back to it. Seventh item on my list is that the Council was going to investigate a means of monitoring the development and employment, jobs specifically, outcomes from business policies and mixed-use area of change policies that seek employment outcomes. And that this would be to inform the emerging local plan and also to provide a mechanism of monitoring the effectiveness of the proposed allocations in terms of delivering particular development outcomes. And that there was also to be an investigation of whether the Council was prepared to commit to this work in an appropriate paragraph in the plan by the 26th of November. And you'll recall that that emerged from the conversations with the Civic Society yesterday. And then I have two ditto items on that, because it initially emerged in terms of the conversation about business-related and employment-related policies, but it was relevant also to floor space quantities that are yielded out of retail elements of mixed use and area of change policies, and it was also relevant for the quantity of housing that was delivered out of those policies. Item number 10 on my list, the Council was going to spend a little time discussing with the Civic Society the degree to which there was common ground on the wording of and or changes to ALRTW2A, and either reach common ground or state remaining uncommon ground, again by the 26th of November. There was then this more general issue that I've listed here at item 11, that the Council is going to consider the addition of wording to the plan which explains that the housing and employment figures, and particularly the housing targets in the plan, are maybe not as precise as they appear, and that that is a good thing because it is based on the assumptions being conservative, and that there are a range of potential outcomes with higher yields that could be accommodated on the assessed sites, the allocated sites, and that the Council, in appropriate circumstances or with whatever reservations you may feel necessary to put on that sort of statement, would be supportive of max yield, in inverted commas, on some of those sites coming forward, as opposed to a conservative yield by the 26th of November. The 12th item on my list relates to what we spoke of in yesterday's hearings as the safety net provision in respect of area of change policies. And this is in circumstances where a master planning process was not kicked into being by active collaboration between the developer parties to an area of change, that the Council was making clearer than is currently the case on the face of the plan that it would remain as leader of a master planning process and even may use relevant statutory powers to ensure progress and delivery of particular sites. Now, again, consideration of what the Council is prepared to include in those area of change policies by the 26th of November. We're now on to today, the 13th item on my list. Policy ALSTR3, which is the rail safeguarding policy. The Council is going to seek an updated response from Sainsbury's by the 26th of November. And that needs to be a document that comes into the examination library. The 14th item on my list is an action on me that I am to put further questions on the rationale for the decision not to proceed with the Buell Water upgrade to Southern Water, exploring essentially the consequences of what is currently proposed, which is the deletion of that policy, and also asking them to respond to the latest position in terms of economic and housing forecasts arising from the areas that that piece of infrastructure serves, recognising that it doesn't at the moment serve, as I understand it, anywhere in this borough. A letter has been drafted, and I believe Ms. Duncan has already sent it.
ID 13 has gone?
It has gone. So that one's discharged. As a parallel to that one, on ALSTR 4, the Council undertook, because it appeared to me to be not particularly appropriate for me to be writing to neighbouring local planning authorities who aren't parties here, the Council was going to write, or email, it doesn't need to be a letter, to Wealden and Rother, I believe they're the right councils, to inquire whether Buell Water has a current safeguarding policy in any of their existing development plan documents or emerging DPDs, and also just to seek any advice that they may have had from Southern Water as to whether such policies are sought going forward, and that, if it's possible to achieve that by the 26th of November, would be very, very usefully done. That's the end of all the substantive matters. Now, there's a couple of very procedural ones that just relate to dealing with the audio files, but in relation to the substantive matters, any concerns or ones that you think I asked for and have failed to pick up?
I just did want to clarify in relation to the Civic Society. My recollection of the discussion was that it was related to the Urban Design Framework policy, and that the Civic Society were seeking a sort of increased emphasis on the historic quality of Tunbridge Wells, Royal Tunbridge Wells as a town.
Just let me recheck my notes. I may have just written down the wrong policy number. I think you're correct, and I think I've just written down the wrong policy number, and then I've confused in my mind the conversation that was had around the checking on the university proposal, which actually has been brought forward by that conversation with the leader. And this should have been ALRTW1.
My recollection is that they were going to sort of draft a revision to that policy and accompanying text, and were to submit it to us. But I'm happy to correspond with them and remind them of the commitment they gave.
Given that I don't seem to have reflected that one in my notes as well as perhaps I should in the circumstances, I think probably the best starting point would be if you can email the Civic Society, and we will agree that that item is as we have discussed, but just put it to them first and say, are you happy? Okay, so I've reworded that item 10. Civic Society to draft a form of words for revision to ALRTW1 and to seek common ground and or specific uncommon ground with the Council by the 26th of November. That feels more accurate to me. Okay, so everything else happy. I'll form this list into a publishable form, and Mrs. Duncan will publish it. If we can then just look at the arrangements that we need to make for the end of today, or as shortly as possible after the end of today, I think well, I'm just thinking about when certain things might be achieved. Would the 16th of November be okay to set as a target for getting the audio onto the web, which allows maybe a little bit of time for queries to move back and fro about how to manage the files and technical issues?
I'll certainly speak to colleagues about doing that, and I believe you offered
I did.
the advice of the planning inspectorate, which we may need to take up.
Yeah.
Yeah.
If you need that advice, what would be really useful would be to know that as early as possible on Friday, so that ideally I can get somebody tasked with answering any questions that you've got, with a view to getting an answer to you by the end of Friday. Otherwise, I can see this beginning to drag on. So if we say technical questions by start of business, 13th of November, and then finalisation by the 16th of November. Now, obviously, I'll revisit that if there turns out to be some sort of insurmountable technical problem that you don't have the right software to compress the files or something of that nature. Okay. By the 16th of November also, what would be very, very useful would be to have a finalised and publishable written note of the business on hearing day one, for which the audio file is of insufficient quality to publish. If you can ask whoever's been preparing that on the council side to prepare something in draft, maybe by the end of Friday, and that can then go to Mrs. Duncan. I would actually like to look at that before it's published, because I can compare it with my own notes, and then we actually have something that, you know, we are in agreement on in terms of the accuracy of its content.
Sorry, the end of tomorrow?
By the end of tomorrow,
yeah.
for a first draft shared with me.
Yeah, my colleague is writing that up now, so I'm sure that will be possible.
Okay. So that brings me to the end of those actions, and then just finally arrangements for clearing the hearing venue. Prosaic though they are, what I will need is the ability just briefly to park my car down at the Monson Way entrance so that I don't get a parking ticket while we're putting boxes of documents back into it, if that's achievable.
And if you want any help loading, you know, we can provide people to help you load up as quickly as we can.
Well, I think maybe that's the best thing to do, that we arranged I go and collect the car, and then maybe somebody can be standing in the foyer with the documents and we can just plonk them straight in. Okay, that's resolved. Is there anything else about forward arrangements that we need to sort out now, because it's either got to be published or included in the next iteration of the programme? I don't think there is.
Not that I recall, other than the sort of rearrangement of the dates, and I believe 1st of December was principally to concentrate on 5-year land supply in the mornings,
Yes.
and then matters for Tunbridge Wells following on from that.
Indeed, and that's been the subject of a separate email communication that's come through the programme officer. So we'll pick that up and make sure that's reflected in the next iteration of the programme. Okay. I think then that's that business done. So, what I started off by saying that we wouldn't have a break this afternoon. What I'm going to suggest now is that we do call a brief break. I'll stay here. If it's possible, just to make a progress check on the negotiations that are going on elsewhere, and maybe just come back and advise me briefly whether we are still on target for 3, or whether it feels as though this is a process that isn't succeeding and that we need to make more space and accept a written process. So I'll wait here until I hear that news. Thank you very much. Testing. Yep. Now, Mr. Hinton, it's probably about 3 minutes past 3 now. We still don't seem to have the Cooper Estates team with us. Are they likely to attend?
They're imminent, so you may just wish to give them 5 more minutes. So
okay.
We've concluded our discussions.
Well, look, if we go back into session, because I think there's just one matter that we can deal with that, in respect of which there's no prejudice to them. Mr. Tofts and I reviewed the homework list, and I don't know whether or not he's mentioned it to you, but one of the items on it was that the council were going to seek further clarification on the members/leaders position on the location of a university campus development in the borough and its relevance, if any, to our TW2A. Now, I had that down as a matter to be resolved in writing by the 26th of November, but I gather you may have had a conversation with the leader that means you can clarify it now.
Yes, sir. I can conclude that particular matter, and would advise that, in summary, is the same as I indicated earlier in the week, namely that the Borough Council does have an aspiration to attract a university presence to the borough/town. A number of discussions have been held regarding various possibilities and hence sites. But to date, those discussions are at an early stage and aren't in a position to really direct you to particular sites or a selection of sites which are in a sort of short list. However, as I indicated earlier in the week, when we were discussing the particular allocation, the range of uses that are referred to in regard to this site and this area of change include educational, and we also gave you our information about site coverages and proportions and how we felt that might play out in a manner which would safeguard the heritage assets. So really just to confirm the answer I gave earlier this week.
If I can just reflect my note back to you, Mr Hinton, that you had spoken to the leader who had confirmed that the Borough Council has an aspiration to attract a university presence to the borough or the town, and the town, and that a number of options are under consideration and early stage discussions have proceeded, but all are at an unformed stage.
That is correct, sir. I haven't actually spoken to the leader personally, so it's probably preferable to say that I confirmed the corporate, the Borough Council's position rather than referencing the leader.
I will do that. Okay, that has been done. For Cooper Estates' benefit, just to be clear, there was an outstanding action on the council in relation to a particular allocation site within Tunbridge Wells Town Centre, where I had an outstanding piece of information that I'd sought from the council about a corporate policy position. And we used the time whilst we were waiting for you to just finalise that. It will all, in a sense, as well, be on the recording if there's anything that you have any concerns about. However, we have reviewed all of the outstanding homework items, and the only one left is you.
We're very privileged.
Now, again, I am in your hands as to who leads out on this, given that you've had substantial discussions now that may have altered the approach that you might have taken to it before. So who am I going to first?
Well, I'm happy to start. Thank you. First of all, thank you, sir, for allowing us that time, which I think I can say on both sides has been very productive and useful. What we are proposing to do is, first of all, if I can lead on explaining what we understand the Council's methodology to be, just to ensure that you, sir, also understand it.
Indeed.
And then we have reached agreement in relation to certain figures. 1 point of disagreement as to approach, and we can explain that. And also we have considered your question about bed spaces and units and sites, and so I deal with that. And then Cooper Estates then, in light of all of that, have some very brief submissions to make on the effect of all of that on the case. We can put this in writing as well, but I felt that it would be useful at least to go through questions on methodology orally, because then, sir, if you have any questions, you're here now and we're here, and we can deal with them this afternoon. But we can follow it up with something in writing if that's helpful.
I'm very grateful for that offer. I mean, I think it's always useful with these sorts of matters to deal with them orally because of the exploratory capability that comes with that. But to make sure that nothing then finally gets overlooked in the wash-up, a written submission would be a good idea. We'll wait until the end before we set a date for it, but let's run through and see where we get.
All right, thank you, sir. So I'll start with the way the figures have been set out in the Council's email. And this, as you'll recall, arose, sir, from the question as to where the 170 unit figure had come from and what it represented.
Yes.
And it's derived from two things. First, completions, and secondly, extant planning permissions. Yeah. And within extant planning permissions, there are those under construction and those not started. And you can see that from the table. The question about gross and net figures, which we have got to the bottom of, and I'll explain how it works out, is that the way the Council calculates it is because of its annual monitoring, they take off or deduct from their net completions those units that are to be demolished, if I put it in sort of simple terms, but i.e. redeveloped.
Or decommissioned.
Or decommissioned or whatever, taken out of the figures, and they remove them in the context of the net completions, even if the development itself has not yet been completed. So, for example, if I take the top, if you look, sir, at the extant C2 permissions as at 1st of April 2015 page, which is the small page,
yep.
The top application reference there, which says still under, as at April 2015, under construction. So if you look at the application reference number, you will be able to link that through to the completions page, and it's 3 up from the bottom under 2014-15, and it's the same application, and so you'll see there beds -2.
Yep.
So although that has not been actually completed, the redevelopment element of it, because it's an extension, it obviously this extension involves replacing 2 of the existing units with 2 new ones.
Okay.
-2 goes into the net completions, and then the gross figure is in the extant permissions, even though it's still under construction. The same follows for the next ones. So the one down, 1101-268, redevelopment of 12-bed care home, loss of 12 bed spaces, you see is recorded in 2013-14, and that's 4 up from the bottom of the 2013-14. And there you see -12. And then, and so on. We have one dispute as to principle, which I'll come on to in relation to the 54-bed care facility, which is the 4th one down, but that's Hawkhurst one, but I'll explain that in a minute. But the maths is correct, we've been through, in that each time you get a redevelopment of something with a loss of certain bed spaces, the loss is reflected in the net completions page, although it's not reflected in the extant permissions page.
Yes.
But so you need to look at them both together.
It's double entry bookkeeping.
Yeah.
And the loss is recorded at the time the loss accrues.
Yes. Accrues,
and the
yes,
benefit
right.
may not be recorded or is not recorded until the time the benefit accrues.
Yes.
So in fact, you're running losses ahead of benefits.
Yes. Yes. I think
Which actually should be sufficient
Yeah.
to give us all a reasonable amount of confidence in the accuracy of the
Yeah.
approach.
So I think as a result of that, what we've been able to agree is that looking at the period, because these figures start from 2008, but the plan period starts April 2006. The Council has no evidence of any provision of C2 units between 2006 to 2008 that it's able to rely on. So we've agreed 0 for those years in the absence of any other evidence. So looking at a period from April 2006 until 30th of September 2015, which is 9.5 years, there are net completions, which takes into account some of those under construction. It assumes that half of those under construction will have been completed by September 2015, because we're looking at status at April 2015. We don't know on the ground, obviously we've passed that date, but nobody's been able to actually find out the reality. But assuming half of those have been completed by then, you get a figure of 170 over a 9.5-year period, which gives an average each year of 17.9, round up, say, to 18, of 18 units a year during the core strategy plan period to date, as an average. Obviously, that has fluctuated very widely, as can be seen from the net completions, and in 2008, 2009, there were no completions, the same in 2009, 2010, and then more recently there have been more. So it's fluctuated widely, but as an annualisation rate, it's 18 a year. The other figure to take into account, we have agreed, is that if it is assumed that all of those under construction as at April 2015 will be finished and completed by April or 31st of March 2016, then you are looking at a 10-year period from April 2006 to 31st of March 2016. And there you have a completions number of 296. So over a 10-year period, that's 29.6, or rounded up to 30 per year over a 10-year period from April 2006 to March, April 2016, assuming that all of those that are under construction will be completed by then.
Which is considerably more substantial than 18 per
Yes.
year. So again, the view one comes to there is that there is a substantial body of in-construction work that's relatively close to completion.
Well, I think the view is that there's a substantial amount of construction work being undertaken at the moment.
Yeah.
And there wasn't any being undertaken at the beginning of the plan period.
Yes.
Yeah. Yes. And neither party is able to predict what will happen in the future, and the Council is not alleging that the 30 per year is going to be the same going forward, and they're not relying on that at all as a figure for future years. Yeah. It's simply a reflection of what happens to have happened over the past. But we would obviously say that these are, this is without any allocations. This is by chance, and it has been widely fluctuating during that period. The next point, which we have agreed to differ on, is the approach, as I mentioned, to Hawkhurst, and this is the 54-bed care facility. The Council, which ceased operation in 2001-2002, and there are 90 units under construction. The Council treats those 90 units as all new because they say that the 54-bed care facility use was abandoned, and therefore we treat it as dead and buried and not a redevelopment. And so the 90 units are as if it was a completely vacant site. Having looked at the officer's report into that permission, we take issue with the suggestion that there have been abandonment of the former care home use. Mr Buchanan has written a commentary on that report, and we'd ask that we can submit that to you, sir, along with the planning officer's report and the relevant paragraphs. And we say, reading the report, the planning permission was very much granted in the context of an existing C2 use, and there was no suggestion that it had been abandoned. And therefore, it's appropriate to see this, albeit there has been a period of time when it's been vacant, to see it as a redevelopment of an existing C2 facility rather than wholly new units.
Okay. Before we go much further on that, I mean, in terms of the broad question of abandonment, I mean, this is actually going to go back to whether that was a use that existed before the relevant day when the 47 Act came into force, and therefore was a use that was lawful by way of being existing, because, you know, my understanding of the law on that is that such uses are very easy to abandon, and that the passage of 2 or 3 years of vacancy on such a use is sufficient to abandon, and that the effect is of there being a nil lawful use. Whereas if there were extant planning permissions granted for particular use, that's much harder to abandon. So the facts should be quite easy to assert.
I think so that our position is based on the planning officer's approach to the grant of the new planning permission, and his planning judgments that he made at that time on the former use. So we would just ask you simply to consider the report, and you will need to reach a view as to whether it's appropriate to see that as a redevelopment or as a new.
Or as an in principle.
The difference it makes is that it's a difference of 36 between the parties for both the 10-year period and the 9.5-year period. I haven't gone and divided that to work out what difference it would make in an annual, on the annual things, but that would be very simple to do. You'd simply minus 36 off 170 for the 9.5-year periods, or minus 36 off 296 for the 10-year period. We can do that, but it's simple maths. But it's a relatively significant number in the overall context, so that's...
Because it's a reasonably substantial development.
So that's the difference between us on that, and we would ask that we can put that report and a commentary in, and that's agreed with the council.
Okay. Well, obviously, if the council disagree with any of this, I'm sure they'll draw it to my attention. So.
Oh yeah, I would. Yeah. The next point. I'm going to come. I'm going to come to some sort of final submissions on the effect of this on other arguments in a minute. But the next point was your question, sir, on the definition of units and bed spaces, and on essentially the council have taken the descriptions in the planning applications and counted what is in those planning applications. We've used units. The council are happy to use units. It may be that some bed spaces are disguised as units or vice versa, and you could have a situation where one unit has 2 bed spaces in it, or 2 rooms, one for guest accommodation. So there could be an element of error with all of this, but in the broader scheme of things, it's an impossible task to go through all of them and work out exactly whether it's a bed space or a unit, and we're content to treat the figures as broadly accurate for units.
As long as you and the council are on the same page.
Yes. So
that is probably good enough for my purpose.
None of them are sites, so we are in agreement that these are all either units or bed spaces figures. That none of these figures relate to sites containing multiple units.
That's the important point.
Yeah. So it may be give or take here or there, one or two error either way, but we're not, none of these figures are relating to sites with multiple units within them. So just thank you, sir. And finally, seeing what we've now agreed in terms of those figures in context, so I would first of all draw your attention to the SHMA requirements, because obviously that's covering the period 2013 to 2033, which most of that is going to be within our period for these purposes. And as we set out in our representations, the SHMA identifies an annual C2 need of 110 a year. So whether one looks to the figure of 30 a year or 18 a year, even looking at the Council's best figure of 30 a year over the core strategy period up until 2015, 2016, in our submission, it's still falling very short of the identified need for C2 in the SHMA. And as a consequence, we submit that the only way to meet that need is for there to be an actual allocation, rather than leaving things to the market and windfall sites. The second point to make that this table, the tables do highlight, as I've already mentioned, is the huge fluctuation that there has been in delivery over the plan period. And the Council is not suggesting that there is any trend towards the future in any way, up or down. It's unknown. And therefore, we would submit that simply looking at what's happened historically is inherently unreliable as a predictor of what's going to happen in the future, because there is no plan in place for it. Yeah. So that's why there needs to be an express allocation to deal with that need.
And therefore, in your contention, part of the position would be that in order to deliver to meet this need, an allocation is necessary, because without one, anything can happen between a lot and nothing.
Yes, exactly. It may be that suddenly next year the market dictates that everybody wants to build C2 accommodation and loads of sites come forward, or it may be that nobody wants to. But that's leaving it entirely to chance.
So it is the role of the plan to signal to the market what is expected, required in order to meet underlying need.
Yes,
okay.
and in the context, obviously, of the vulnerability of the ageing population and the MPPF desire for a wide variety of housing types.
And obviously, what we don't need to do is to return to the primary submissions that were made on Tuesday, which were essentially drawing my attention to your view that this is a matter that is sufficiently engaged in the core strategy for the argument that there is a consequential need for an allocation to flow out of the core strategy without needing to do what I referred to as peeling back the onion and attempting to revisit the strategic framework of the core strategy, because that is something we sort of discussed the legal basis under which such an approach might be taken. It seemed pretty clear that we weren't going there, but content. Okay.
basically what I've said in writing for your note and also for the benefit of the council if they can agree it. Not necessarily the submission parts of it, but agree the annual rates that I've set out.
Well, actually, I will go a little further because my take on this is that given that you've made progress on agreement around the figures, it would be useful then to state the points of agreement, the points of disagreement, and the relationship, as you see it in your statement, between those and your submissions to date, so that when I'm then reviewing everything, an accidental "so what" factor doesn't creep in, which is, where these things have been technically agreed, but I'm
sort of the significance of them,
struggling to re-engage with the significance of them for whatever reason. Now, I don't think that's a particularly high risk, but you're going to put something in writing anyway, so you might as well put in another 2 or 3 sentences to actually pin this back to the thesis set out in your main written submission. And when I've heard from the council, we will turn to a date when that should occur. But I think, in fairness, unless you've got detail that you want to put to me on other matters, I should turn to Mr. Hinton, because he's had his Toblerone up for a very long time.
Thank you, sir.
Thank you, sir. It was just to seek a point of clarification from Cooper Estates with their referencing to the figures in the SHMAR. If they could just confirm with reference to the SHMAR document which paragraph or table they're referring to, because I have a concern that the figure mentioned is not specific to C2 but is of a wider category of care need housing.
Well, that's a sensible question. And I think it also gives me...
Sorry, sir, and if it helps, I would say that the council relies on table 80 of the SHMAR, which is referring to specialist housing C2 rather than anything of a wider general nature.
Well, so I'll say where I got the figure from, because it's from our October submissions, and we may need to go to the SHMAR as well to check that they are accurate in light of the SHMAR. But it's page 7 of our submissions, paragraphs 2.16 and 2.18, which refers to the draft SHMAR, and in particular table 5 on page 18 and table 6 on page 18 of the draft SHMAR.
Okay. Well, I think there is a very particular point that's worth...
So, yes, core document 3.7a is the final version of the SHMAR.
We're looking at table 81.
81. Need for residential care. Need for residential stroke nursing care bed spaces. That's paragraph 8.5.1.
Correct. Correct. Correct, sir.
Right, so yeah, that figure, which you get 40 a year from 796 divided by 20, we did take into account in paragraph 2.18 of our objection, but we also took into account a figure of 70 units a year, which comes from the additional 1,400 specialist dwellings for older persons in the borough, which we understood was on table 5 on page 18, but it may be in a different place in the final version. Do you want? Yes. I mean, if I pass over to Mr. Buchanan, because he's got the draft schma there, and he can explain more.
Thank you, sir. I think Mr. Hinton and I are essentially looking at the same things, because the references which are in my October submissions refer to the tables much earlier in the schma report, whereas the tables that Mr. Hinton has taken to you come much later on in the schla, but essentially it is the same information. So just to reiterate, Table 81 at paragraph 8.51 of the schma contains the figure of 796 need for residential nursing care bed spaces. That's consistent with paragraph 2.18 of our October submissions. But of course, sir, that's only one element of the overall C2 provision, i.e. in Table 81, residential nursing care bed spaces. The other element which contributes to C2 need is then, it's unintentional I'm sure, but Mr. Hinton was right in the first place, it's at Table 80 of the schma, a few paragraphs up at paragraph 8.43. And Table 80 identifies a need of nearly 1,400 for specialist housing. And so that 1,400 figure at Table 80, paragraph 8.43, is the same 1400 number we referred to at paragraph 2.16 of our October submissions, and that gets you the 70 units of specialist dwellings. But the key point, sir, is that paragraph 8.45 of the SHMA confirms that specialist housing includes sheltered and extra care housing. So in other words, it's the other component of the overall C2 need. One component being the Table 81 residential nursing and care bed spaces, but the other component being the Table 80 specialist housing for older persons, which at paragraph 8.45 is confirmed includes sheltered and extra care housing. So that's not conventional C3 housing, sir. That is specialist housing that is not conventional C3, but nonetheless is to be counted as part of the C2 need.
Well, therein lies the rub, because what we need, in terms of taking this forward, I think, is a clear understanding of where the breakdown is between stricto sensu C2 and then other ways in which special housing need, inclusive of mechanisms such as extra care, will be delivered into the housing supply. And then to make the maths work, to understand how much of an allowance rests in the SHMA for that. Does that make sense?
Yes, sir. I'm very happy to assist you on the question of whether or not, in fact, that number of nearly 1,400 is entirely paragraph 8.45 specialist housing, sheltered and extra care housing, or whether or not of that total, a proportion of that is the sheltered and extra care housing. And the rest is some other form of housing. But on the face of it, I can only reasonably conclude that what it cannot be is conventional C3 housing, because that wouldn't fall within this table at all. So whatever it might be, if there is a missing element in my submission, it still forms part of the C2 need.
Okay. Notwithstanding that it is including a range of potential supported housing options that wouldn't be classed as C2, and the customers for which may not be looking at C2 provision. I'm testing this because I really want to make sure that we don't double count.
Indeed, sir, and I think the answer is in my submission in what I've just said, that if in your mind, sir, there is a suspicion that there may be, for example, a sort of McCarthy and Stone type of provision that is buried somewhere within this number of 1,400, that wouldn't be correct, because that form of older persons housing would be counted within the conventional C3 housing element. There is this, sometimes I feel rather black art as to where that boundary is between a C3 older person's form of accommodation and where it transcends the boundary into C2. But I don't think that needs to trouble you, sir, as far as Table 80 is concerned, because whether or not Table 80 is composed of entirely sheltered and extra care housing or some other form of C2 use, it matters not. It's still part of the overall C2 need. What I would submit we can conclusively say is that for the purposes of Table 80, it would be in error to conclude that any part of that 1400 could in any way be described as some other form of older person's accommodation, but meeting a C2 under a C2 heading, because it wouldn't get counted in Table 80, it would get counted in the conventional C3 housing numbers.
Well, that's your submission, and I've heard it. And then I'm going to turn to the council and just test their position on this, which may agree with yours, but may not. Mr. Hinton.
Thank you, sir. Reluctantly, we take a different view, and would just direct you to paragraph 8.45 of the SHMA, where which you were just had a quote from, but which continues: the number of homes set out in the above table are considered to fall within C3 use and thus form part of the overall objectively assessed need for housing identified in this report. And I think that's quite clear in the SHMA, and puts a different position to the one that you've just been presented. And I am concerned that if there was a disagreement with that paragraph and what it was saying, and a different interpretation was being put on it, we would have been alerted to that earlier in proceedings, because we could have then sought to agree to disagree or reach an agreement or do further work. But I think it's quite clear in the SHMA what those figures are and what the tables relate to.
I'm looking at those words again on screen in front of me now, paragraph 8.45, which clearly calls up the table above it. Specialist housing includes sheltered and extra care housing. The numbers of homes set out in the above table are considered to fall within a C3 use and thus form part of the overall objectively assessed need OAN for the housing identified in this report. So, proposition being from the council, therefore, that general housing allocations are the places where those will come forward, and the numbers, albeit that we've had the conversation about the fact that this allocations plan won't meet the full numbers requirement of the SHMA for good reasons, but a share of those numbers will rest within the land that's proposed to be allocated within this plan, and that I would be, in the council submission, confusing matters and misdirecting myself if I were to take the view that any of that figure emerging from Table 80 for Tunbridge Wells ought to be addressed anywhere other than in general housing allocation.
That is completely so, sir.
Okay.
Thank you, sir. I think even if Mr. Hinton is right, the paragraph clearly says that specialist housing includes sheltered and extra care housing. So I think just taking that first sentence, whichever way you cut it, a proportion on Mr. Hinton's submissions, a proportion of the 1400 is quite clearly intended to fall within the sheltered and extra care housing category. And so in my submission, that quite clearly is not within a conventional C3 use. And we can, if it assists you so, we can make written submissions on what is and what isn't a C2 or a C3 use. That's the first point, sir. And the second point is that in my submission, sir, the second part of paragraph 8.45 has to be read in the context in which these indications of need are then taken forward to become a policy on housing requirement. And in that context, sir, it's quite correct for sheltered and extra care housing, and indeed other forms of C2 housing, to be counted within or against the conventional C3 housing requirement of a local plan. That's now well established, and planning practice guidance confirms that. So I don't think I certainly don't agree with Mr. Hinton's interpretation of 8.45 on that point. I think it's in my submission. Table 80 is contributing to a C2 need, but contributing to a C2 need. But paragraph 8.45, second paragraph, is simply recognising that in terms of separate question of assessing the extent to which the council is delivering its housing requirement for that purpose, it's quite right to include these sorts of specialist housing types as part of the monitoring target towards meeting the housing requirement. So I think that would be my interpretation of 8.45, sir.
Okay. You're clearly not going to agree on this, are you? Which means that I am going to have to take this away and essentially, as I've said on a number of other cases earlier on, put it into the umpire's basket. However, there is a need to think about timing in that respect, because what we need to make sure is that we're in a position when we start to move through individual sites and individual allocations in December to know whether or not, in principle, there is a need for additional allocations that deal with essentially the position that you've put to me in your submissions of principle. Now, I'm just trying to think about what the best way to do to communicate my thinking on that to you, what the best thing to do would be. Because I think, given where we've reached and given that there is still a substantial point of disagreement and that some of that disagreement is technical, I think there would still be virtue in there being written submissions from yourselves, and I think there would be virtue in there being written submissions from the council. And I think it would be, in the circumstances, unfair and unwarranted to expect those to appear any earlier than around the 24th of November, which is the same day on which the general housing written submissions are due to appear. I will then need some time to turn my mind to them, and I can provide some guidance in respect of my reasoning on the balance to be struck between the pair of them. Now, if I'm looking at the date on which I might issue agendas, if we just look at that briefly. Realistically, I've indicated publicly that I'd be issuing agendas on or about the 24th of November in any case, because that is 1 week prior. If we've got a day in reserve for hearings on the 9th of December. And if I were to suggest that this matter ends up coming back then rather than any earlier on, that would mean that I could issue a supplementary agenda on or around the 2nd of December, which could also provide some steerage, for want of a better description, some guidance on whether or not we are dealing with a need to find bodies of additional land. Now, I think that's a process that allows me to take benefit from Council's position, your position, the difference between the two, gives me some thinking time, and also provides the pair of you a place to come to talk about the consequences.
Thank you, sir. That's achievable from our point of view. So, written submissions by the 24th of November. Shall we say 4 p.m. or?
Yes. Close of business.
Yeah.
Yeah.
To be exchanged simultaneously.
To be exchanged simultaneously, but not heedless as to each other's position. Because, I mean, what has clearly been very useful today is that some conversations have happened and some
agreement has
been reached.
Yeah.
And I would very, very strongly endorse the proposition that, that conversations continue, and that if you've got a choice between, you know, blindly firing documents at each other at point-blank range across the wall at 4.
Yes. Thank you, sir.
Yeah.
No, well, we will do our very best to...
Or being in agreement.
And then, so then on the 2nd of December, you, sir, will provide, in the context of an agenda, essentially a decision or guidance as to whether there is going to be a need to find additional land. And then the 9th of December would be reserved for hearing on what? So, because obviously if you've decided that there is no need...
If I have decided that, if I take the view that there is no need, then essentially there wouldn't be a great deal of virtue in hearing further oral submissions at that point.
Yeah.
However, that time is there if I were to take the view that there is a demonstrated need and that translates in the context of this allocations plan to a need to actually delve into the pipeline and look at sites. That would be a conversation that would need to be had. Now, I'm conscious that if I give that indication, that the Council would no doubt also want to put some submissions to me in principle, and I can guess what they would be, that they may well be. So we think this is not the correct approach to take for reasons. And so on the 9th, almost irrespective of which way it goes, there may be a virtue in saying to yourselves, as a matter of sheer fairness, that if I actually reach a view that, in principle, I don't think your position is made out, that I would, in any case, provide an opportunity for you to come back and say to me why you felt that was wrong before I reach a concluded position.
So that makes sense. So your agenda will be your preliminary view on the papers, and then both sides will have the opportunity to make oral submissions in respect to that on the 9th.
Oral submissions by way of support or rebuttal.
Yes.
And then put to me, if we are talking about extra land, where it might be found, and if we're not, that's an end to the matter.
Yeah. Do you want to say that?
So I just checking my calendar, and if I've got this right, then currently we are programmed, or you are programmed to hear our site-specific representations on the Cooper Estate site as an emission site on the 2nd of December.
Yes, and what I think Mrs. Duncan and I need to do at this day is just go away, reflect on whether that's sensible. I think it makes sense to extract C2 from any further consideration of emission sites in its entirety and pull everything into something like that. That would be the best way forward. Because, there's no point putting it to a waste of time and attendance on a day when we can't make progress, because only very briefly have I issued my in principle reasoned position on it, and so you haven't had a chance to think about what you might say, and indeed the council hasn't had a chance to think about what they might say.
Yeah, so this, essentially the 2nd of December session may be conjoined with the 9th of December.
Indeed.
Yeah. Sorry, sir. I do apologise. I thought you were still typing, but no, we're very happy with the course that you're proposing. So long as so long as it does mean that your in principle decision is still reviewed in the context of the inquiries as a whole, which I understand it will be.
Absolutely. I think one of the dilemmas that there always is in dealing with these sorts of issues is, I guess, the dilemma in the mind of the inspector about how to frame sufficient of a concept of their own thinking to ensure that parties can make useful submissions whilst also not ending up of fixed mind on matters that it would be utterly inappropriate to be of fixed mind on. Now, all I can do is kind of give you my very clear warranty that I will endeavour to be as productive as possible in providing a target to aim at, whilst also give you my clearest professional undertaking that I will not form a final view until the matter is fully heard. Now, if I can go to the council, because I've had, deep dialogue with Cooper Estates, but the council may think this is all nonsense and they would like it done another way.
Thank you, sir. On a positive note, we would welcome your guidance and initial findings, if I may call them that, because I think that would be helpful. And as always, we can meet the timetable and the programme that you've outlined. I am disappointed, however, that there is further delay in concluding this particular matter and hearing representations. I had hoped, the council had hoped, that we would have been able to conclude agreement on the figures and given you submissions on this today, enabling you to go away and consider what you needed to consider. And the council, based on the discussion, had the discussions and exchanges that happened earlier in the week, were strongly of that view coming to the hearings today, and therefore I have to record our disappointment that these matters have been extended, and I think we feel that that could have been avoided. Having said that, we welcome the opportunity for your guidance, and we will cooperate with the programme and obviously provide statements. Our position on some of these matters is obviously clearly set out in our statements already, and I think, as you've indicated, some of the points we will make in the submissions in due course regarding the appropriateness of allocating a site in the circumstances of the evidence that you've heard and will hear. I'm sure what we say will come as no surprise to you. I am concerned, the Council is concerned, that we seem to have been led into an examination of the SHMA, which clearly isn't the purpose of this examination and these hearings. The SHMA was jointly commissioned by two authorities. It's a piece of evidence, it's not a piece of policy, and both ourselves and Sevenoaks are quite clear on the work that we commissioned. We've had the benefit of the discussions with the consultants. So our position on what the SHMA says and the categories of use is quite clear, but I'll leave it there, sir.
Well, I hear what you say, and again, I think it's important for myself that I make clear so that everybody in this room hears it from me, that the SHMA is a source of evidence and not a source of policy. That the SHMA has also been prepared to inform the preparation of a plan which is yet to be. It's a local plan, and it's not part of the evidence base for the core strategy. We are in that grey area, that nebulous land between what is necessary to be investigated in terms of the soundness of an allocation local plan relative to its core strategy and the ambitions and the policies set relative to its core strategy and the ambitions and the policies set out in that core strategy. And I'm testing this hard precisely because I've had representations put to me that on their face appear to be rational, that we are in a world where we are looking at the implementation of the core strategy. So that's the starting point. We are also in a difficult place because we're in a place where if we look to the core strategy's evidence base on its own, we don't find compelling evidence that really supports any proposition as I see it around C2. So, of necessity, Cooper Estates find themselves looking at more recent evidence. So, as long as we're all aware that we're in difficult territory, we're in the grey area, but at the moment it appears from my assessment of the issues that we haven't crossed the boundary line into an attempt to essentially examine an emerging core strategy or to place any weight on the SHMA over and above its simple value as a source of evidence about a particular form of use, then I think we're probably on reasonably safe ground. Now, if you're both prepared to take my explanation of the endeavour that I think I am engaged in away, if you disagree with me, if you think, either of you, that we're trespassing out of the territory that we should be on when conducting an examination of a plan of the nature of the one that's in front of me, please tell me now, because I have absolutely no interest whatsoever in carrying out an exercise which will then open up, a potential further legal challenge with all of the uncertainty that may flow from that. It's very much at the heart of the service that the planning inspectorate seeks to provide to communities, to planning authorities, is a clear and lawful examination of the plan that is in front of the examination. Now, I'm seeing the right body language around the room. Everybody seems to be
Yes.
reasonably content and to understand that position.
Thank you, Sir. I think that reflects our position. I would just say that the reliance on the draft SHMA was clearly flagged up in our written objection of October 2015, and this figure of 110, the 70 and the 40. And so if there is any suggestion that we are ambushing the Council with this today, that's certainly not been the intention. I simply repeated what was already in our written evidence. And the Council has had many months now, since from the beginning of the examination to object to the written evidence, and it hasn't done so.
In that respect, when I saw your statement on the steps that we took was to talk about formally having the SHMA put in by the council themselves, so your document was available and flagged to all councils. And that was a step to which the council agreed.
Yeah. Thank you, Sir.
That's fine, sir, from the Council's point of view.
Thank you very much, Sir.